Back with you on the newsfeed, and thanks for staying on. The Constitutional Court says it wants to hear from those challenging Parliament's public participation process on the National Health Insurance Act. Various groups have dragged government to court against the act since it was signed into law in May 2024. The Board of Healthcare Funders is one of those, and we're joined now by its Managing Director, Dr. Katlego Mothudi. Good to have you, Doc, and thank you very much for coming on this afternoon. My understanding is that as of today, where we are sitting May the 15th in 2026, the Constitutional Court has not yet issued a final judgment on the constitutionality of the NHI Act itself. However, it has shifted its focus to prioritize challenges regarding Parliament's participation process over the challenges on the President's assent. Has this decision been communicated to yourselves? How has it been communicated to yourselves, and how have you responded to it?
Good afternoon, Mr. Mothudi, and thanks for having us. We received communication through our lawyers about a week ago, in which case the Constitutional Court was asking for representations from the various parties that were involved in their suggestion of taking this challenge of the President's ascension to the bill off the roll while awaiting outcome of the parliamentary challenges. We submitted written papers, and a ruling then was made that they would indeed go ahead with the removal of the presidential challenge, and they would rather first hear the parliamentary processes challenges that would sit in May.
Yeah. What do you make of the argument that is being raised by the ConCourt that says, well, if that particular challenge of the Parliament process succeeds, then the challenges to the President assent becomes moot? Are you in agreement with that?
We were not in agreement. We would have loved that we have a finding because we saw that these processes, while one led to the other, were actually separate. And we believe that both Parliament and the President erred in terms of processing the documentation with the inadequate consultations. We also noted that the President ignored quite a number of representation made to his office prior to the bill being signed into law and even afterwards. And we believe that there is a case for the office to answer in terms of the processes. And we have already had one leg of this process at the High Court. While the actual merits of the case were not discussed because the Presidency and Ministry of Health challenged the placement of this case at the High Court and said that it's a constitutional matter. So we were looking forward to just first hearing the thought processes around the challenge, and then secondly, the outcome in terms of how the President handled this matter.
Has this thrown a curveball in your strategy or tactics on the matter of the reviewability of the assent?
Not really, because while we have several cases in place, one does not really depend on the other, but there was a process that we followed. We believe that there is a case to answer on its own merit, but it does not necessarily have a big impact on the other challenges. This is a view that is not supported by the Constitutional Court, in that they say that if one or two of the challenges that are going to be heard in May are successful, this part of the challenge would become moot. But we believe that there have been legal arguments that are advanced that require to be heard.
Meanwhile, in January, we heard the Minister of Finance saying, well, look, there is no disagreement as far as he's concerned between all the parties about the necessity of universal health care. It's the modalities, it's the challenges that you would raise, maybe that certainly could be spoken about around the table where all these parties can reach a settlement out of court. Are you favorable to that call by the Minister?
I mean, obviously, a negotiated settlement would be great, Thabo. But fact is, all the institutions that have taken this matter to court have been for years trying to get the department to talk through the various processes. Our institution, the Board of Healthcare Funders itself, started as early as the days of the Green Paper, and through a decade-long process of submissions, presentations, etc., we have seen none of the recommendations that were forwarded by us or any of the other entities being considered. So we do not know what a negotiated settlement looks like or what it would entail, because it was not for lack of trying on our part to have these discussions. The court process was really a last straw of the dice for us because of the frustrations that ourselves and many of the institutions have endured.
Is there something that could be crafted in your view, and what would that look like that would allow implementation to proceed?
We have a procedural challenge at the moment because the Act is now in place, and for anything to be reversed, it has to go back to Parliament. So whether it's through a negotiated settlement or any other means, there has to be a process where the law has to be revised. There are many suggestions, either from ourselves or any of the entities, in terms of a different approach. We have forwarded this through our various submissions. And we also believe that the Act itself is not the entire discourse, or does not capture the entire discourse. There are many other things that are outside the Act itself that we think could propel us towards universal health coverage. From the private sector as well, we've been talking about increasing access to healthcare services through implementation of pared down options that could still be run by schemes. We have postulated that maybe between 10 and 15 million more South Africans that are working but not insured could have access. And you'd know that just having access to healthcare services already increases the coverage index as far as universal health coverage is concerned. We are cognizant of the challenges that government has in terms of resources, and we believe that it really has to be all hands on deck, and we believe that the private sector is an important resource and a partner that the government could look at to actually reach the goal of achieving universal health coverage.
No. You're arguing for a sequenced transition. What could that possibly look like?
I've mentioned that there are other platforms or processes that are in place. We also have known or acknowledged that universal health coverage is progressive realization. In fact, there will never be a point where you say you have coverage, maybe with a CSI or coverage service index of 100%. There are particular steps. From our side, which is what is within our powers, we believe that increasing the number of products that medical aids are allowed to have could go a long way to doing that. If you take off 10 million people off the roster of government or responsibility of government, you then have government having a bigger budget to spend on fewer people. We also believe that there needs to be pricing certainty. The Health Market Inquiry in 2019 made pronouncements through its recommendations that there should be a structure that is set up that assists schemes and the private sector players to sit down on a regular basis and negotiate prices, set up a schedule of benefits and their prices. That has not happened. And that's why every year you hear entities, you hear companies and individuals complaining about the escalation of cost in terms of healthcare service provision in the private sector. We believe that if you bring at least some of this, that could propel us sequentially to universal health coverage.
However, even if that was brought to the table, you're saying you could cautiously approach the negotiating table, but you will not cease court action.
As I said, the Act is a legal document and there are processes. So for as long as these challenges that we have identified in the Act we do not think it's implementable, and it's not because we do not know what should happen. It is because, from a legal perspective, operational as well, the Act has been really torn apart and examined to see whether the intention will actually be achieved. But we do believe that we can still have discussions that could propel us in that direction, Tau.
Doc, appreciate your time. Thanks so much for coming on. Board of Healthcare Funders Managing Director there, Dr. Mothudi, on the reaction to the decision now by the ConCourt to focus really on the parliamentary process that would have led to that act being in place over the challenge that they would have brought to the president's assent of the NHI Act.